I sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Stop shutting my mic off, please.
Your Honor,
Why are they shutting my mic off?
because he's talking.
I'm the federal witness of the United States federal government. I demand some respect, you. All I did was trespass on property.
Ma'am, you got to create the community that you want to live in.
Sheriff will set a new bond in this case in the amount of $5,000, special condition you not have any contact with the victim.
Yes, sir.
Thank you, Your Honor. Ms. Richfield? Your Honor, this is Ms. Richfield. Before she begins, I need her to sign her notice of invocation of constitutional rights. You sign this, ma'am. It's going to protect your rights here in the future. I'm Andrew. I'm at the Public Defender's Office. Don't say anything to anyone. Don't talk to anyone who's not your attorney, and you confirm that you're an attorney. Don't make any phone calls discussing your case, and really, quiet is the best thing to do at this moment. I need one more signature right here on the application of indigency. Ma'am, right here. Sorry, Your Honor, I did not have a chance to speak with her beforehand.
Okay.
And I have not received a police report in this case either.
State have one?
I just have where she was picked up on a warrant.
You got the affidavit? 'Cause y'all both come up here and look at the affidavit. It's kind of long. What's your name, ma'am? And you're charged as a principal in first-degree murder charge.
We do have a PC argument, Your Honor.
Go ahead.
Ms. Scritchfield did not physically strike the alleged victim in this case, the deceased. Further, she personally testified that there was no desire on her part to see him dead. I don't believe first-degree murder is the proper charge.
State which be heard.
Yes, Your Honor. Based off the affidavit, it's the state's position that she was the principal. And can I have just a moment? Based off the warrant, it does allege that Ms. Scritchfield was involved in facilitating this alleged murder of the victim, and we are asking that she be held at no bond. If Your Honor does not find probable cause based off the warrant, we would ask for 24 hours to supplement.
Well, judge has already found probable cause already. I know it's an initial appearances, and I can reverse that, but I'm not going to find. I've read the affidavit thoroughly. I'm finding sufficient probable cause, but I'm going to set a bond in this case in the amount of $75,000.
Thank you, Your Honor. All right, don't say anything else, all right? Don't talk to anyone except your attorney.
What's your name, sir?
Mr. Thomas Fouts, Your Honor.
Okay, so you're charged with offense of petty theft. Bond set at $250.
Thank you.
What's your name, sir? So you're charged with trespass on property after warning. Set bond at $250.
Thank you, Your Honor. Mr. William David is next, Your Honor. I believe this may be a change of plea. We do have an offer and a plea form.
Talking about David Williams?
Yes, sir.
Okay.
Mr. Williams? Hey, I'm Andrew. I'm an attorney with the Public Defender's Office. We have an adjudication of guilt, credit time served offer in this case to resolve it. Know what that means? Would you like to resolve it today? All right. Sign right here. Your Honor, at this time, we do retract our previously entered plea of not guilty and enter a plea of no contest in this case. The offer from the state is adjudication of guilt, credit time served, and court costs.
What's your name, sir?
David Williams.
How do you plead to the charge of open container?
No comment.
All right. Accept it. You may approach. Have you gone over the plea form, sir? You understand that you're entering a no contest. How do you plead to the charge of open container?
No comment.
All right, I'll accept your plea. I've read the affidavit. I'm not going to adjudicate him guilty of this charge. Adjudicate guilty, sir. Credit for time, sir. I'm not assessing any costs.
Thank you, Your Honor. Have a good day, sir.
Thank you. I ain't used to doing no misdemeanor plea forms. Sign. What's your name, young man?
Caden? What is it? All right, that's you.
What's your name, sir?
Good morning, Rucker.
Good morning. What's your name?
Caleb Robinson on behalf of Mr. Rucker.
I couldn't hear him. What
Caleb Robinson on behalf of Mr. Rucker.
Rucker? This is not the person I have here.
Yes,
Yes, sir. That's what I was asking, because
No,
the
it's a
name I was
guilty
looking at
and
wasn't the
no
name you were saying, so that's why sometimes I can't hear good, so I didn't know if it was me or him. Mr. Rucker, you're charged with the offense of violation of probation.
There's a new law, there's a warrant for. A Demarion. John, I don't have the affidavit for the new law violation.
Yeah, I'm gonna look and see. Okay, the violation of probation bond is set at no bond. Now, this,
John, I don't have an affidavit for the new law violation. I would be asked to be heard in regards to bond and the violation of probation.
let me look at it. You're charged with robbery with a firearm. I don't know if the state has it, but if you want to come look at what affidavit they have here, I'll let you come up and look at it, sir.
May we?
Yeah. It's up under here somewhere. State, you want to come up here and see this affidavit?
Oh, I'm sorry. I have it.
Oh, if you got it, then that's fine. I can get it to him. You also got another out-of-county one on the violation of probation, too. Mhm. State, you say you already had it. Thank you, sir.
Your Honor, I would like to be heard specifically in regards to probable cause in regards to the new law violation. I understand that this is based off a warrant, but the warrant is based on identification through a ski mask that only identified a tall black male specifically and no other identifying features, saying they're identifying from the eyes in a photo lineup. I don't think it reaches the burden of PC for the warrant to be issued. We'd also ask to be heard to regards to bond on the violation of probation, given the lack of, we would argue, no PC for the new law violation that's the basis for the violation. I don't think there's enough to hold him no bond on the violation of probation.
State.
Yes, Your Honor, probable cause was already found by the issuing judge, so we would ask that that probable cause stand and the order of no bond for the violation of probation remain.
Well, I'm reviewing, I still can, at initial appearance, review the affidavit. I'll note for the record that the judge did find probable cause that signed the warrant. I've reviewed the affidavit that she also reviewed too, and I'm gonna find probable cause for the arrest of robbery with a firearm. She said bond at no bond. I'm gonna set bond as first degree felony punishable by life. I'm gonna set bond at $25,000 in that case with no contact with the victim. On the 2 VOP cases, though, I'm gonna leave bond set at no bond, sir.
Also, he also has an open case. He's out on ROR for.
Oh. He has a possession of firearm, shooting from a vehicle, shooting into occupied vehicle.
Yeah, that case is no process, I believe, or no info.
Okay.
They took no action on 2 of the counts, but the possession of a firearm by a person found to commit delinquent act is still open.
Madam Clerk, look this case up because that what she just said is not one of the charges on this paper here. So I just want to make sure it may have been something. Sometimes the clerk's office stuff gets filed late, but we'll see. It's not going to make a whole lot of difference with his release at this point, but
It'll make a clear record.
I tell you what, since it's not, he already had no bond in 2 cases in this, I'm just going to take, I'm not going to take any action on that case.
Thank you, Your Honor.
That's fine. Whatever the warrant says. Morning, sir.
Morning, Judge.
All right, what's your name, sir?
Brian Fay.
Okay. Counsel?
Good morning, Judge. We're here today hoping to get Mr. Fay out. We don't, I would argue there's no probable cause.
Let me go ahead and tell him what he's charged
I'm
with and
sorry,
all
go
that
ahead.
good stuff. I know you want.
Sorry, Judge, I apologize.
Don't get him out, but let me take my time. And
Yes,
do
sir.
my
Yes, sir,
job
Judge.
here. Sir, you're charged with the offense of battery. At the present time, it's no bond. I see we have a victim. I didn't know if you want to take testimony from her.
Sure, Your Honor.
Can I get you to raise your right hand, please? Do you solemnly swear that the testimony you're about to give here today will be the truth, so help you God?
Yes, Your Honor.
What's your name, ma'am?
Anna Nelson, Nelsen.
Okay. Counsel, I'm gonna let you inquire, and I'll let the state inquire that after if they choose to. So you can go first, counsel.
Well, Your Honor, technically, she's not my witness.
I'm not his witness. I am the victim.
Go ahead.
Good morning. I just have a few quick questions for you regarding release.
Yes, ma'am.
Are you seeking contact with Mr. Fay?
I would hope to never have contact with him ever again.
Are you afraid of him?
I am terrified of this man, and I would like 24 hours, 48 hours to move out of our apartment, and then no contact ever again.
So you two reside together?
We do at this time. We have for the last year, and he knows that. And this is not his first charge against me.
Okay. And is your name on the lease?
No, ma'am, it is not.
Okay. No further,
And that has been held against me multiple times.
no further questions from the state at this time.
Counsel, you have any questions?
I do, Your Honor. Ms. Nelson, have you ever been physically violent with Mr. Fay before?
Myself?
Yes.
Objection.
What's your objection, counsel?
Relevance.
It's relevant, Your Honor, because the night in question, we believe that Mrs. Nelson was actually the aggressor to Mr. Fay.
Sustained objection. I want to know what happened that night if you want to go into that, but I don't want to know what happened before, so.
Okay, you want to know what happened that night?
Yes, sir. I sustained objection.
Thank you, Your Honor. The night in question, did you physically assault Mr. Fay?
Which night in question are we talking about?
Last night.
Last night in question, I did not physically assault Mr. Fay.
You did not place your hands and punch Mr. Fay in the face or throw anything at him?
Objection asked and answered.
Overruled. You can answer the question, ma'am.
I can answer the question.
Yes, ma'am.
I put my hand on his face to defend myself after he dragged me on the ground and yanked me across the floor. I put my hand on his face because he was on my back. I have marks on my face, marks down my legs. There are no marks on his face.
And last night, you were trying to grab his cell phone from his hands, correct?
Yeah, because he was showing me text messages of everything and he said, look at it. So I grabbed the phone and then he went to grab it back from me.
Did Mr. Fay give you consent to grab his phone from him?
He said, look at it.
But did he tell you to come and grab the phone from him?
I don't know. He was wasted.
And then did you assault him in the back of the head afterwards?
No.
Okay.
Just because you are his best friend and his attorney. Also, I would like to state that while Mr. Fay was being arrested, his attorney, Brandon Stewart, called me and threatened me that I was ruining his life and he was going to take me down. I would also like to say that Brian Fay called me multiple times this morning from jail and threatened me that
Judge,
I was going to ruin his life and he was going to take me down.
Can I further question the witness, please, Your Honor?
Go ahead. You say you had no, you said what now?
Can I further question the witness, Your Honor?
Yeah.
And the apartment that you live in, did you move out of this apartment?
I am in the process of moving out of it right now. I am moving out of it today.
Whose idea was it to come to Mr. Fay's apartment last night?
I'm sorry?
Did Mr. Fay force you to come to his apartment last night?
He told me yesterday morning that he wanted me home. I have text message proof that he wanted me home. He said by 5 o'clock. He showed up at 7 p.m., wasted, and started screaming at me at 7 p.m. when he wanted me there at 5 p.m.
But you voluntarily and knowingly came to Mr. Fay's apartment, correct?
That's my apartment as well, and he knows that I was moving out of it, yes.
Were you under the influence of alcohol last night?
I had some drinks. He was wasted and probably...
I'm not asking you that, ma'am. Were you under the influence of alcohol
Yes,
last
I
night?
was.
How much alcohol did you drink last night?
I don't know, like 5 shots of Jameson.
You had 5 shots of Jameson last night.
Probably, and he probably had 50.
Okay, so you had 5 shots of Jameson, and you remember clear as day is exactly what happened last night.
I remember everything that happened last night. Yes, I do. Do you want to ask him that? Because I can guarantee you he has no recollection of last night at all.
You got another question?
He is a horrible human being. He's been
Ma'am, I got enough. I got the picture.
The state has no further questions.
Counsel.
This time.
Judge, for the charge of the DUI charge, Your Honor, we find there's no probable cause. The police officers were not, they did not observe Mr. Fay driving, which caused them to then pull him over to then make a determination of whether he was under the influence or not. It was more like Miss Nelson had called the police. They were chasing after him. Once they pulled him over and had him outside of the car, is when the police started to make mention of perhaps he was slurring his words and things of that nature. But prior to the pullover itself, Your Honor, there was no basis to think that Mr. Fay was driving drunk at that moment. Or under the influence. So therefore, I would argue that the state doesn't have the probable cause, at least in regards to the DUI charge, Your Honor, and I would ask for ROR on that one. In regards to the battery charge, Your Honor, I believe it's clear both parties were inebriated. This relationship is not one that is something to smile about or something that's perfectly harmonious. Both of these parties are very much know what they're doing, Your Honor, and therefore I would ask that my client be released. Sorry, Your Honor. Further, this is my client's apartment. He's on the lease. It's his livelihood. He has work he has to go to, 2 jobs. He has a master's. He's an accountant. He has very much everything going for him.
As to the DUI charge, I'm gonna find his probable cause. Bond set at $500. They had 2 counts of DUI, so it's $500 on one and $100 on the other. As far as the new battery case is concerned, I'm going to set bond in the amount of $2,500. Special condition, you have no contact with the victim involved in this case. Ma'am, you say you're moving out of the apartment?
Can I just make one more statement?
No, I'm ready to do what I gotta do. Are you moving out of the apartment?
Yes, sir, I am.
Okay, so if you're gonna go back, if you're moving out of the apartment today,
Yes, sir.
if he gets at some point to be released, he can be released. Now, he can go back to the apartment once as long as she's not there.
Yes, Judge.
As far as he has in case number 2022 CF
That's me.
007639, he has 2 counts. He has a battery domestic violence and an aggravated battery with great bodily harm. Based on what I've heard here today, I'm going to revoke that bond and leave it set at no bond.
But Judge, real quick, in that case.
I'm finished.
Okay. So for no bond, meaning is in.
Yeah.
You would need to have a hearing determination.
Sir, you can go before the judge that said it, but I'm not setting the bond on the case.
Okay. Thank you, Judge.
Hey, no problem. That was great.
What's your name, sir?
Anthony Carrillo.
All right. Ms. Akins, how you doing?
Good morning, Judge. Bryce Akins on behalf of Mr. Carrillo. This is a reset from yesterday, Judge.
Okay. Why was it reset?
There was no probable cause, and the Judge, Allen, gave the state an additional 24 hours for additional reports or whatnot.
State got anything?
Yes, Your Honor, just one moment. I have various emails regarding this. Okay. The state has no objection to releasing this defendant ROR.
Okay.
Judge, I know there was a hold, additional hold regarding the passport. I just want to make sure that the ROR satisfies that, because when he was arrested, they took possession of his passport anyway, so he doesn't even have it to surrender to the court. But I just want to make sure that that's not.
He's released from jail, Mr. Akins. As far as I'm concerned, I don't see. I just go by what's right here in front of me.
Okay, so there's no other holds that hold him other than this case?
Madam Clerk, do you have a hold on him for anything? Well, if you're releasing ROR, who is the victim in the case?
There isn't a victim. It's a financial fraud.
That's what I thought. That's what I was. So we can delete those conditions, man.
Okay, please, all right. Thank you, Judge.
Okay.
Good to see you.
Mm-hmm.
This is Mr. Dalton Diedrich, Your Honor.
Your Honor, Zad Caven refused.
Okay, thank you, sir.
My apologies.
So I guess what do y'all do? These y'all reset them when they refuse?
What I can do. You're not being held on anything else?
They didn't. No, I didn't find any PC. They agreed to RR since there's no PC, so. What's your name, sir?
Dalton Dietrich.
Dietrich. Oh, okay.
We do have a PC argument, Your Honor.
Let me tell him what his charges are first. So you're charged battery, dating violence, and aggravated assault with a deadly weapon, domestic violence. You can go ahead and make your argument now, sir.
Thank you, Your Honor. This is a he said, she said case. There's no clear proof. My client has denied this at every turn. He does admit that he possesses the knife, but it's simply in his vehicle for purposes of criminal mischief, according to the report, that the alleged victim in this case is not reliable. They have not met the burden of PC, Your Honor.
Well, that sounds like that's something that could be brought up at a trial, but as far as probable cause is concerned, I'm gonna find it as probable cause. I'm gonna set bond. I'll take that into consideration. I'll set bond in count one in the amount of $250. As for the aggravated assault, I'll set bond in the amount of $500. In both conditions that you have no contact with the alleged victim in this case.
Your Honor, Joan Chevelle is outside medical.
Okay.
I don't know if you want to give that 24 or 48 hours. By my understanding, that you may be in there for a while.
Yeah, we can get 48 hours because I know about this case. I signed a warrant on the case, so.
That's fine by me, Your Honor.
We can reset that for 48 hours. More than likely, it will probably be longer than that.
Yes, Your Honor.
What's your name, sir?
William Mahone, sir.
All right. Hold on.
Buchanan?
Yes, sir.
Okay. I did not receive a report in this case, Your Honor.
What, from William Mahone?
Yes. I see,
I mean, I don't know if the state has it. I got two cases of violation of domestic violence injunction. He said at no bond. He was also out on ROR on a violation of an injunction too.
we won't make a PC argument if it's a new law violation.
There's two of them, so. So you say, I thought you said you didn't get it.
No, we have not, Your Honor.
So you want to see it?
Yes, Your Honor.
All right. You said you had an argument on that?
No argument, Your Honor.
Okay. Okay. As to one of the counts of violation of domestic violence injunction, it was set bond in the amount of $10,000, a special condition you have no contact with the victim. Next charge, violation of domestic violence injunction, I'm set bond in the amount of $10,000, special condition you have no contact with the victim also. You out on bond, well, RR, in case number 2022 CF12875. I'll revoke that.
Your Honor, he's in on that case. That's the case he's in on. The one he's out on bond on is 5490. 12875 is the violation of domestic injunction and the ag stock.
Oh, you say it's case number what now? Yeah, I'm looking. Okay, it's 2022 MM, I guess 549. Thank you, ma'am.
Yep.
Bond, be able to get out, but
I'm gonna revoke that RR, set new bond, and in that case, in the amount of $5,000.
you had this 20.
I also see another case too that I missed.
Yes,
Oh, no, aggravated stalking after injunction.
on that case.
And the bond is gonna be set at $1,000 if that charge with condition to have no contact with the victim.
Thank you, Your Honor.
Mhm.
No, we can get you a bond. Alexa.
What's your name, sir?
Gregory Mullins.
Okay. Ms. Mullins, you're charged with false imprisonment, domestic violence, obstructing justice by hindering communication with law enforcement officers. Just give me just a second, sir.
We do have a PC argument, Your Honor.
Go ahead.
Oh, thank you, Your Honor. This is a he said, she said domestic violence, Your Honor. There's no concrete proof of the allegations made by the alleged victim in this case. Further, they maintain separate residences. And additionally, Mr. Mullins is very gainfully employed and owned his own business. We would request that he be given a low bond or alternatively IOR or placed on PTR in this case. And I understand that he may have other cases, and we request that he be given a bond on those cases or be released on those cases so he continue to run his business where several people are gainfully employed.
I don't have any information before me about any other cases now that I see.
He is on state probation, Your Honor, VFOC.
Oh, well,
Hold on him as well. So he would not qualify for PTR.
okay. Well, he's not here on a violation yet, so.
No.
Yes, Your Honor.
On the false imprisonment, sir, I'm gonna set bond in the amount of $2,500. Special condition, you have no contact with the victim involved in this case. Battery, domestic violence, I'll set bond at $1,000 with same condition. And count 3 of obstructing communication with law enforcement, $1,000 bond already. And that's correct. He's not to return to the scene and no weapons or firearms involved.
You can get it done before they file this. I'm sorry, I missed it. It was like 2,500, I think. Thank you, Your Honor.
What's your name, sir?
Tristan Smith.
Smith, you're charged with the offense of trafficking in cocaine 400 grams with a firearm.
We do have a PC argument, Your Honor.
Let me tell them what the charges are first, and then I'll let you go through your argument. Count 2, aggravated battery with a firearm. Count 3, aggravated assault with a firearm. Count 4, possession of firearm by a convicted felon. Count 5, possession of firearm by a convicted felon. Count 6, possession of firearm by a convicted felon. Count 7, grand theft third degree of a firearm. Count 8, grand theft third degree of a firearm. You go ahead with your PC argument, sir.
I'd like to address the aggravated battery. The police report clearly states that the alleged victim claimed that she was pistol whipped in the head by Mr. Smith. But the police report also notes that she has no wounds or bruising, indicating that she was struck in any way. Additionally, as for the aggravated assault with the firearm, she never testified that she was threatened verbally with it in any way, simply that the firearm was present and may have been pointed at her. Additionally, testimony shows that she was out to get Mr. Smith arrested, that she allegedly made several claims that she was going to get him or similar such things. As for the possession cases, I'd like to point out that all those possessions are constructive and none of them are actual. They just happened to be in the vehicle that he was driving. And further, for the grand theft third degree firearms, there's no indication that he knew that these firearms were stolen in any manner. So we don't believe the state has met their burden of probable cause here.
Got a witness over here. I don't know if the state, you want
Yes,
to
Your Honor.
take
Would you like for me to question the witness or address the
It's
problem?
up to you.
I'll question the witness first.
Can I get you to raise your right hand, please? You solemnly swear or affirm the testimony you're about to give here today will be the truth, so help you God.
Yes.
Good morning.
What's your name, ma'am? I need to know that.
Tynecia Smith.
I couldn't hear you.
It's Tynecia Smith.
Okay, all right.
Good morning, Ms. Smith. Are you seeking contact with Mr. Tristan Smith?
Yes, we're together.
So you would like to have contact with him moving forward?
Yes, I'm going through a medical condition right now with treatment with my eye.
Okay.
So he helps me.
Are you afraid of Mr. Smith?
No. It's just that he at times can have a little anger issues, but it's nothing like extreme. No.
Okay. And so do you wish to continue living with Mr. Smith?
Yeah, 'cause I need help.
No further questions from the state
I
for
need
this
help.
witness.
Nothing from me, Your Honor.
As it pertains to probable cause, the affidavit does say that the victim testified that she was hit with the firearm. As to the drugs, defense states that they were constructive possession. They were in the vehicle at the time he was driving, and the possession of the firearm by Mr. Smith the firearm was in Mr. Smith's possession, despite him being a convicted felon, and we would ask that you set reasonable bonds in this case.
Find probable cause for the charges. See, I'm gonna go through this here for bond. Trafficking in cocaine greater than 400 grams. With the firearm, I almost said bond at $100,000. As to count 2, the aggravated battery with the firearm based on the victim's testimony in this case, I almost said bond at $1,000. Count 3, aggravated assault, $1,000. With special condition now. She testified here in court that she didn't have a problem having contact with him, so no hostile contact with him. Count 4, possession of firearm ammunition by a convicted felon. I'm gonna set bond at $5,000. Count 5, possession of firearm by a convicted felon, $5,000. Count 6, possession of firearm by a convicted felon, $5,000 bond. Count 7, grand theft of a firearm, $5,000 bond. And count 8, grand theft of a firearm, $5,000 bond. Thank you, ma'am.
Thank you.
What are you gonna do? What's your name? What's your name, please?
Muhammad Abidin.
You're charged of battery, domestic violence. I see that there's a person over here. I don't know if that's a witness for the state or the defense. Ma'am, raise your right hand. You solemnly swear or affirm the testimony you're about to give here today will be the truth, so help you God.
Yes, I do.
What's your name?
Sabina Abedin.
State.
Yes, good morning. Are you seeking to have contact with Mr. Abedin?
Yes.
And are you afraid of him?
No.
If something like this were to happen again, would you be willing and able to call 911?
Yes.
Okay, no further questions from the state.
State, defense.
No questions, Your Honor.
And he does qualify for PTR, Your Honor.
I'm gonna release your PTR, special condition, you have no hostile contact with your wife and no arguing or fighting. Thank you, ma'am.
Thank you.
What's your name, please?
Sierra Caesar.
You're charged of battery, domestic violence. Can I get you to raise your right hand, please? You solemnly swear that the testimony you're about to give here today will be the truth, so help you God.
Yes, sir.
What's your name?
Messiah Baptiste.
State, I don't know.
Yes, good morning. Are you seeking contact with Miss Caesar?
Yes.
Are you afraid of Miss Caesar?
No.
And if anything like this were to happen in the future, would you be willing and able to call 911?
Yes.
No further questions from the state.
Nothing from defense.
You qualify for PTR?
He could, Your Honor, yes.
Release you to PTR. Special condition, you have no hostile contact with the victim involved in this case. Thank you.
Thank you.
What's your name, sir?
My name's Grover, Craig Grover.
Okay. So you're charged with battery, domestic violence. Just give me just a moment.
You have a residence here in Florida?
So it's done on the last week of my vacation.
Anything from the state or the defense before I set a bond? I've read the affidavit.
It's a he said, she said, Your Honor. Neither of these people are U.S. citizens, which I frankly don't know how that affects anything here. But I would argue that the state has failed to meet the burden of probable cause, as there's no concrete injuries or concrete testimony proving anything otherwise.
State wish to be heard.
There were observable injuries on the victim at the scene. As detailed by law enforcement, there was scrapes to the knee and bruising, brush bruising. State just asked that you set a reasonable bond.
That bond in amount of $500, no contact with the victim.
I was going to make the same argument, Your Honor. He's not a U.S. citizen. It's unsure what kind of access he has here in the United States. We would request a PTR, ROI, so he can return home and get counsel and mount a defense.
Please.
State does not object to PTR.
We can't, so he's in the UK, we can't supervise him out of country.
So I'll release him all right. Y'all want to do that then? Yes, ma'am.
The thing is, I need to be there. I need to see my children and my.
Be able to contact people. This is the best possible outcome.
Say no conditions.
Hello.
What's your name, please? I can't hear you.
Brandy Jones.
Okay. You're charged with battery, domestic violence. Guess there's a witness here. Raise your right hand, please. You solemnly swear that the testimony you're about to give here today will be the truth, so help you God.
Yes, sir.
What's your name, sir?
Christopher Moulton.
Good God, so I can hear you.
Christopher Moulton.
All right. State.
Good morning. Are you seeking contact with Ms. Jones? Are you afraid of Ms. Jones? And if something like this were to happen again, would you be willing and able to call 911?
Yes.
No further questions from the victim.
Nothing for me, Your Honor.
Qualify for PTR?
He could qualify, yes, Your Honor.
Release your PTR with the special condition that you have no hostile contact with the victim in this case. That means no arguing or fighting. Thank you.
Thank you, Your Honor.
What's your name, sir? I can't hear you, but.
Timothy Matthews.
Okay, you charged with battery, domestic violence. Just give me a moment. I reviewed this affidavit earlier. I find probable cause for the arrest. Set bond in the amount of $1,000.
He does qualify for PTR, Your Honor.
He does?
Yes, he does.
I release your PTR with the special condition that you have no hostile contact with, no contact with the victim. It looks like you all may live together, so you may be allowed to go back one time to retrieve belongings with law enforcement. Thank you, sir.
Yeah.
What's your name, please?
Tabitha Bayhead.
Yeah, you're charged with possession of cocaine, bond set at $1,000. Possession of drug paraphernalia, bond set at $100.
Thank you, Your Honor.
What's your name, sir?
you're out on bond on something else.
Sir, you're charged with carrying a concealed firearm, bond set at $2,500. You out on bond in case number 2022 CF 012235. Count one, possession of cannabis greater than 20 grams. And count two, possession of cannabis with intent to sell, deliver, and carrying a concealed firearm in that case too. I don't know, I'm gonna revoke the bonds that you will own on those cases. As to the possession of cannabis greater than 20 grams, I'll set bond at a new bond at $1,000. Possession of cannabis with intent to sell, deliver, $7,500. Carrying a concealed firearm, you can set it at $10,000.
All right, so just so we're clear, Your Honor, you're revoking and setting new bonds in these cases?
Mm-hmm.
Thank you.
Yes, sir.
You got bond.
Your Honor, Gail Alexander's behavior.
Behavior. Let's bring them tomorrow at any means necessary, so they can't run to jail, so. We're gonna let them take over the jail here. Come to court when they get ready.
Name?
Kenny Hill.
Thank you, Mr. Hill.
What's your name, sir?
Kenny Hill?
Mr. Hill, you picked up on a failure to appear. Bond
Yeah,
set
I
at
was-
$1,000, sir.
So I was unsure. I mean, I wasn't informed about when.
Speak to your attorney.
That's why I said a bond, sir. What's your name?
Your Honor, Martin Dennis refused.
You were picked up on a charge of possession of cocaine, bond set at $1,000. Possession of drug paraphernalia, bond set at $100.
Are you Mr. McBride or Martin? Yes. I'm sorry, Your Honor. This is Mr. McBride, not Mr. Martin.
I thought he said.
Martin refused, Your Honor.
Martin refused? Okay, I'm sorry. I don't want to give you the wrong charges, sir. Oh, we can bring him tomorrow, then means necessary too. And folks sleepy, they don't have to get up, they get up. What's your name, sir? Daniel McBride? McBride, okay. You're charging one count of possession of ammunition by a convicted felon. Set bond at $2,500. Second count, possession of firearm with ammo by a convicted felon. I'm gonna set bond at $2,500, and count three, possession of firearm by a convicted felon, $2,500 bond also. Yes, ma'am. All right, thank you, sir.
Thank you, Your Honor.
What's your name?
Parker?
Courtney Parker, sir.
All right, Mr. Parker, hold on one second here. So you're charged with possession of firearm by a convicted felon?
Yes, sir.
I'm gonna set bond in the amount of $2,500. Possession of concealed weapon by a convicted felon, bond set at $2,500. Resisting an officer without violence, bond set at $500. Possession of cannabis less than 20 grams, bond set at $100.
Thank you.
Your Honor.
What's your name, sir?
Giovanni Perez Fuentes.
You're charged with robbery with a firearm. It's a first-degree felony punishable by life. I reviewed the affidavit. I'm going to set bond in the amount of $50,000. In this case, a special condition, no contact with the victim. Count two, armed burglary of a conveyance with a firearm. Set bond in the amount of $25,000, a special condition, no contact with the victim. Count three, tampering with physical evidence, $150 bond. Petty theft is count four, bond set at $100. Thank you, sir.
Thank you.
Your Honor, Prasad Alicia, she bonded.
Thank you, sir.
Your Honor, Colt also Jose Enrique is outside medical.
Don't make any phone.
He's what now?
Outside medical.
Okay, we'll reset that one in 48 hours. Yeah, I won't be here Monday. Oh, that slipped out, didn't it? Okay. What's your name, please?
Reynolds, Heather.
Heather Reynolds? Okay, ma'am, you're charged in count one with possession of fentanyl, bond set at $1,000. Count two, possession of heroin, bond set at $1,000. You out on jail on bond Well, it says bond slash,
It's she's on PTD for count one of the possession of cocaine.
Got to do a 4-hour class 2 years ago.
well, you got new law violations, that's why you're here though. So, in that case, which is 2021 CF 009207, I'm gonna revoke the bond in that case, set new bond in the amount of $5,000.
Your Honor, can we get a lower bond on that? The fact that she was on pretrial diversion indicates that she has very little criminal history. It does seem like she was close to completing it. $5,000, I believe, is a lot of money for possession like that.
I know, counsel. I do drug court, I did it for 15 years, so I understand the situation. I'm trying to force something else to happen.
I understand, Your Honor.
Okay, thank you.
A bond, yeah. It's gonna be expensive. There we go.
What's your name, please?
Jeremy Smith, sir.
Thank you.
Mr. Smith, you're charged with a failure to appear. Bond is no bond in this case. Thank you, sir. What's your name, please? Thank you.
Mr. Stover?
Yeah.
Ma'am, what's your name?
Woody Stover.
Okay. You're charged with the offense of sale and delivery of fentanyl. Bond is set at $1,000.
Thank you, Your Honor. Okay, don't talk to me about that. Don't talk
Okay.
to anyone about that, only your attorney.
Okay.
What's your name, please?
Melvin Thompson.
Mr. Thompson, you're charged with carjacking with a firearm. First-degree felony punishable by life. I'm gonna set bond in the amount of $50,000. Special condition, you have no contact with the victim. We got some cases here that we're gonna, well, I'll tell you what. Let's see here. You're out on bond in 2022 MM006848. Possession of cannabis. You revoke that bond, set new bond in the amount of $2,500. In case number 2022 CF 011586, you're out on bond on grand theft, third degree of a motor vehicle. Revoke that bond, set new bond in the amount of $10,000. In case number 2022 MM006994, resisting arrest without violence, you out on bond and revoke the bond, set new bond in the amount of $5,000. Thank
And
you.
Your Honor, there was another case found to be open for him as well. It's 2022 CF 009423AO. It was for a carrying concealed firearm. He had bonded out for $2,000.
I'll revoke that bond, set new bond in the amount of $10,000.
Missed all the math.
I don't remember.
It was, the 6848 was 2,500. The last one, the 9423, was 10,000. Yeah, was 10,000.
The lawyer can talk to you about that, sir. I can't tell you what to do.
Yes.
What's your name, sir?
Travis Thompson.
Mr. Thompson, you're charged with the offense of fleeing or attempting to elude a law enforcement officer. I'm gonna set bond in this case in the amount of $5,000.
Thank you, Your Honor.
What's your name, please?
Mr. Wright?
Walter Wright.
What's your name?
Walter Wright.
Mr. Wright, you're charged with possession of cocaine, bond set at $1,000. Possession of drug paraphernalia, bond set at $500. Thank you, sir.
Your Honor.
What's your name, please? I need whoever that is back there. What's your name, sir?
Mr. Charles?
I can't hear you.
Javier Baggett.
Okay. Thank you. Baggett, you're charged with the offense of trespass on property after warning. I'm set bond at $250.
Thank you, Your Honor.
I think that's the only one he has here.
Yes, sir.
Yeah, okay. I'm set bond in the amount of $500.
$500 bond. Not today. We don't have an offer from the state.
What's your name, please?
Do you have offers?
What's your name, sir?
Jesus Antonio Marquez Jr.
You're charged with trespass on property after warning. You set bond at $250.
Is Luis Antonio Marquez?
Yes, sir.
$500. Best of luck. You gotta go. You have $500 bond.
Yeah,
We can't do it right now. I'm sorry.
Your Honor, Stephanie Tyrell refused.
Bring him by any means necessary tomorrow. What's your name, sir? I couldn't hear you.
Marcus White.
Mr. White, I had a Donald Tolson. Mental health? Okay, we'll reset him in 48 hours. Mr. White, you, let's see here. Arrested on the charge of battery. Bond set at $500. Condition, you have no contact with the victim. You out on bond in CF 2020, is this? It says 2000. It says 22-202 here, so somebody got it, wrote it backwards. So it's 2022, CF 005-841. On count one, possession of cocaine, I revoke that bond, set new bond at $2,500. Count two, possession of
Your Honor,
methamphetamine.
they didn't file on count two, only
Okay,
count one.
on count one, so I'll take no action as count two. Thank you.
Thank you, Your Honor.
Yes, ma'am.
You got bond on both cases. You got bond on both cases. Bond? Yeah. I can't speak you out right now. You got bond on both. You were out on one. I gave you the bond on that. You gotta come in. I don't believe you, my man.
What's your name, sir?
Paul David Garaszewski.
So you're here on an out-of-county warrant, out of Polk County, so they set bond at $500. Thank you, sir.
Look, sir. Well, you're gonna get transported to whatever county it is and figure it out from there.
Thank you, sir.
Listen to this, yeah.
What's your name, young man?
Dominique Haynes.
You got two out-of-county warrants, both of them set at no bond. I think it's out of Volusia County. Thank you. Pardon?
I have to wait on them to come.
Yes, sir, they'll come get you.
Your Honor, Mays Jaden, outside medical.
Thank you, sir. We'll reset that, I guess, in 48 hours. What's your name, sir?
I'm Donald Ayers.
I do have a signed plea form in this case, Your Honor.
Okay. Mr. Ayers, you're charged with trespass after warning. You may proceed, counsel.
At this time, we retract our previously entered not guilty, enter a plea of no contest to the charge of trespass. The offer from the state is adjudication of guilt, credit time served, and no return to the scene. Approach.
Yes, sir. How do you plead to the charge of trespass after warning, sir?
No contest.
I will accept your no contest plea. Adjudicate your guilt of this charge, since your credit for time served, special condition that you not return back to the scene, sir. Thank you.
Thank you.
Yeah, I ain't got no money.
Your Honor, Canales Angel of mental health.
Hey. Oh, he's
Who was that,
mental
sir? Angel? Okay, I got you. Mental health.
Need him
We
then.
can reset that one in 48 hours too, ma'am, sir.
Your Honor, Ferguson Franklin is also mental health.
48 too? Yes, ma'am. What's your name, sir?
Marquise Sean Hamilton.
Hamilton, you charged with violation of probation? Bond said at no bond.
Look, sir.
Mr. Hamilton does have reporting requirements, Your Honor.
What you say now?
He has reporting requirements, just so he's aware to report his address change.
So, but he's in no bond, so he has to do what
Yeah,
now?
just whenever he gets out of here, he has to
Oh, okay,
report
okay, all
his
right.
change.
Mm-hmm.
Your Honor, Jimenez Latanya is also refused.
Lamar,
Mr. Recker?
what's your name, sir?
Joshua Barnes.
I can't hear you, sir.
Joshua Barnes.
Barnes, you charged with disorderly conduct. Bond set at $250. Thanks. What's your name, sir?
Henry Caldwell.
You charged with open container.
I don't have offers on any of these, Your Honor.
No objection to a credit time served. Lee?
Would you be willing to take that time served off in this case? Yeah. Go home today? Go home today. Yeah.
You gotta fill out a plea form, right? Oh, you got, okay.
It's Joshua Barnes, right? Run out of paperwork here.
How you plead to charge open container, sir?
Yes.
I accept your plea. Since you the credit time served, withhold adjudication, no court costs.
Is it Joshua?
My name Henry Caldwell.
Oh, shit.
You got anything else, Madam Clerk? Y'all got anybody else back there? All right, y'all have a good day.
Yeah, give me a sec.
Yes, sir. Where says defendant?
You can be here tomorrow? All right.
Hey,
Be
we're
back.
out of here.
Oh, I'm sorry, I don't have a case number. Good luck, Mr. Caldwell.
Must bonded. They are bonded too. Forward, yeah. 60 bonded out. Also bonded out.
One element of the arrest affidavit.
What's your name, sir?
Rafael Garcia.
Mr. Garcia, you picked up on 2 charges. The first charge is possession of cocaine, and the second charge is possession of drug paraphernalia. Counsel, you wish to be heard.
Yes, if I may, Your Honor, thank you. My probable cause argument goes to the possession of drug paraphernalia. While we do find in the arrest affidavit a conclusory statement at the end that said the copper wire was burned, all other details in the arrest affidavit just list copper wire and a screwdriver without more indications of residue being found on them or other drug elements. These are common items that can be used for other reasons, especially a screwdriver, and as such, I would argue there is no probable cause for possession of drug paraphernalia, Your Honor.
State wish to be heard.
Yes, Your Honor. It's the state's position that these items together in combination with the drugs found on Mr. Garcia would lead to the probable cause that he was using these items to consume illicit substances.
Yeah, they make that assumption in the report, but I'm gonna find probable cause for the cocaine. Bond is set at $2,500. As to the just drug paraphernalia, I'm gonna find there wasn't sufficient probable cause. I'm gonna release my warrants to that charge.
Thank you, Your Honor.
Pardon?
The defendant qualifies for direct PTR. Will you consider that?
No, sir.
Thank you, Judge.
All right. The Miguel Hernandez.
Your Honor, I believe Mr. Hernandez has bonded recently and is no longer in custody.
Thank you, sir.
No problem.
Tafari, last name is Hoyte.
He is present and approaching, Your Honor.
Okay. What's your name, please?
Tafari Hoyt, Your Honor.
Sir, you were picked up on the charge of violation of domestic violence injunction. I see that you do qualify for PTR with the bond. I'm going to release you to PTR with a bond of $2,500. I see that it says the victim requests contact, but that will be in violation of the injunction, so I'm going to order to be no contact with the victim involved in this case.
Yes, Your Honor.
Yes, ma'am, with PTR. Robert Marquez.
Yes, Your Honor, he's present and approaching. I believe he will require the services of the Spanish interpreter.
Do I need to call the interpreter?
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good morning, ma'am.
Good morning, Your Honor.
The gentleman's at the podium now. Can you, what's your name, sir?
Buenos días, señor. ¿Cuál es su nombre, por favor?
Robert Edmundo Márquez Cibrián.
Repítame.
Robert Edmundo Márquez Cibrián.
Robert Edmundo Márquez Cibrián.
So you're charged with battery, domestic violence.
Señor, a usted se le acusó de agresión, violencia doméstica.
We'll set bond in this case in the amount of $1,500
Su fianza en este caso es de $1,500,
with the following special conditions.
con las siguientes condiciones especiales.
You'll have no contact with the victim involved in this case.
No puede tener ningún tipo de comunicación o contacto con la víctima mencionada en este caso.
If you all live together, which it appears you do, you'll have one time to go back with law enforcement to retrieve your belongings.
Si ustedes viven juntos, lo cual parece que ustedes vivían juntos, se le va a dar la oportunidad de regresar a la vivienda en una sola ocasión acompañado de la policía para retirar sus artículos personales. Ok.
Thank you, sir.
Gracias, señor.
Jose Rivera.
José Rivera.
I don't know if he needs the interpreter or not, Madam Interpreter. We'll see when he gets up to the podium.
I do not believe so, Your Honor. I have been able to converse with him in English today.
Okay. Doesn't appear he needs the interpreter.
Okay, no problem. I'll stand by.
Okay. What's your name, sir?
Jose Mercado Rivera.
So you get picked up on a failure to appear. Your bond is $250. Thank you, sir.
Okay.
Justin Michaels.
He's present and approaching, Your Honor.
What's your name, sir?
Justin Michaels.
Ms. Michaels, you got, looks like several cases here, so just bear with me. First case on the call, you charged with the offense of trafficking in fentanyl. Bond is set at $150,000. Count 2, possession of drug paraphernalia, bond set at $1,000. And see, the next case you have, you're charged with sale of heroin. Charge bond is set at $15,000 in that case. The next case you have, you charge with sale of heroin, cocaine, bond is set at $15,000, possession of drug paraphernalia, $150 bond. The next case, you charge of trafficking in fentanyl, bond is set at $100,000, possession of drug paraphernalia, $150. Next case, you have possession of, sale of heroin, bond set at $15,000. Madam Clerk, did I cover them all?
Yes, on the first one, you said count one, you reduced it to 100.
Yes, ma'am, I put it at $150,000.
Yes, you did.
Thank you, sir. George Montanez Fierro.
Is present and approaching, Your Honor.
Okay. What's your name, sir?
Jorge Luis Montanez.
You're charged with the offense of driving while license suspended or revoked. I'm going to release your PTR with special condition, not drive without a valid driver's license, sir. Thank you. Ian Pagan, Andiar.
Is present and approaching, Your Honor.
So, what's your name, sir?
Ian Pagan.
So you're charged in first count with possession of marijuana over 20 grams. Count 2, marijuana possession with intent to sell or deliver. 2 counts of that. Possession with the intent to manufacture drugs. You got 2 counts of that. Possession of hallucinogen, it's MDMA. You got 2 counts of that. Manufacture of drug paraphernalia, carrying a concealed firearm, and unlawful use of display of a firearm. Just give me just a moment. I'm going to release you the PTR on each one of those counts, and I'm setting bond on each count in the amount of $1,000. Thank you, sir.
I'm sorry, Judge, which counts is he being released PTR?
All of them. But he got a bond. He got bond. He has a bond on each count, though.
Yes, Judge, you state the bonds
I said $1,000 on each count.
with PTR.
Yes, sir.
Thank you, Judge.
Arnardo Cedric Arnardo. And I guess I see the last name is Perry here, too. All these affidavits look different here. What's your name, sir?
Cedric Perry.
You're charged of violation of probation. Bond is set at no bond. David Plaza Gonzalez.
Is present and approaching, Your Honor. Your Honor, this client would require the services of a Spanish interpreter.
Madam Interpreter, you still there?
Yes, Your Honor, I'm here.
Okay. What's your name, sir?
David Plaza.
David Plaza.
You have 2 cases here. The first case, you're charged with fleeing or attempting to elude.
Tiene 2 acusaciones aquí. El primero es de haberse dado a la fuga.
I'm going to set bond in the amount of $2,500.
En ese caso, la fianza es de $2,500.
Second count, reckless driving.
La segunda causa es de manejar sin temeridad.
Bond set at $500.
En ese caso, la fianza es de $500.
Second count, third count, driving while license suspended or revoked. Bond set at $500.
La tercera causa es manejar con la licencia suspendida o revocada y la fianza es de $500.
Next case you have, you're charged with resisting an officer without violence. Bond set at $500.
El próximo cargo que tiene es de haber resistido arresto sin violencia y en ese caso también la fianza es de $500.
Thank you, sir.
Gracias, señor.
Next person is Adam Rogers.
Is present and approaching, Your Honor.
What's your name, sir?
Adam Rogers.
Mr. Rogers, you charged with violation of probation. Bond is set at no bond. Courtney Rogers.
Is present and approaching, Your Honor.
What's your name?
Courtney Rogers.
Charged with the offense of trespass on a structure or conveyance. I'm going to release you to pretrial release with the special condition you not return to the location in which you were arrested. Brian Rodriguez Nieves.
Is present and approaching, Your Honor. I do have indications he may require the services of a Spanish interpreter, and I would request a waiver of the reading of the underlying.
Okay.
Actually,
Let me just tell him who and find out who he is, sir, and then I'll let you state who you are, sir.
thank you.
What's your name, sir?
Brian Rodriguez.
Okay.
Dave Webster on behalf of Mr. Rodriguez.
Oh, I apologize, counsel.
Yeah, he has counsel up here in Orlando. Okay.
Does he need the services of the interpreter, Your Honor?
Yeah, I still think he needs to interpret. What, do you need the interpreter, sir?
No, no.
Okay, he said he doesn't need him.
Thank you.
Oh, I see a violation of probation. Bond is no bond in that count.
I may be heard after the court goes.
Yes, sir. Go ahead.
Judge, he was put on probation October 24th. He lives in Puerto Rico. We put in for the transfer order. He's been staying at a hotel in compliance with the conditions of his supervision. He had to change hotels, so he had to re-register. Apparently, he was a day or 2 days late, which is why we're here. We have been in constant communication with his probation officer. He's been in constant communication. The fee for transferring the supervision to Puerto Rico has been paid. We're simply waiting on Puerto Rico to accept the transfer. I would ask the court to consider setting bond. While that is pending, we'll deal with the violation of probation. I don't believe it's a willful. Again, he's been in daily contact. My office and I have been in contact. Somewhere the wires got crossed, but there's no prior criminal history. And I would ask the court to consider setting bond on the violation of probation.
Well, it's not a whole lot here to tell me anything about this. I don't know if you, well, state to me. Yeah.
According to the affidavit, he was notified that he had 48 hours to make the change, and this happened 11 days later. The state does have concerns that he is moving back to Puerto Rico, but we will defer to the bench on any decision to be made as far as bond.
Judge, he was living in Puerto Rico. He'd already established residence. He lives with his parents. His father's military, maybe retired military. His mother's a school teacher. We're just waiting on the transfer order. So they've been keeping him in a hotel. There was an issue with the residence, which he had to change to another hotel, and that's where so every time he changes hotels, he has to re-register, and I think that's where the issue may have. But he has done everything. We've been involved in this, again, constantly, trying to get this expedited, get him back home.
Well, Mr. Webster, you're officer of the court. I know you a long time, so I know you're not going to tell me nothing going in the wrong direction. But the problem is, it's kind of different than what's said here. And I'm not saying that you're not telling me the truth one way or the other. It's just hard for me to decide from you saying it and saying it here. And I look at the charges, and I just don't feel comfortable at this point. I just think this may be best to go back to the judge that
We'll take it up with
put him in there.
Judge next law.
Okay. So I'm going to leave him set at no bond. All right. Thank you.
Thank you.
Thank you, sir.
Judge, I'm sorry, what about the other new PC law, the failed to report?